2014-220 State of Arkansas versus Richard Case. Mr. Case, you're appearing here today for a change of plea on the charges against you. Is that correct?
Yes, Your Honor.
On the charge of battery in the second degree, a Class C felony, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to an agreement that's been worked out for you by your attorney, Mr. Cooper. Is that correct?
Yes, sir.
And have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation Mr. Cooper's provided you?
Yes, sir.
The agreement is set out in writing in this document I'm holding up called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
Do you feel you understand what the plea statement says?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties?
Yes, Your Honor.
You also understand from the plea statement that by pleading guilty you're giving up certain constitutional rights you have?
Yes, sir.
Those rights include the right to a trial by jury that you're giving up, the right to be represented by an attorney, in particular represented at trial by an attorney. You're giving up the right to confront the witnesses who would appear and testify against you, and you're giving up the right to appeal. Do you understand these specific rights that you're giving up?
Yes.
And understanding what you're giving up, are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes.
Has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you plead guilty here today, do you acknowledge the truth of the allegations against you in this case?
Yes, sir.
You acknowledge that on or about the 4th day of September 2014 here in Baxter County, that you, under certain circumstances, struck a 7-year-old child by slapping the child across the face, causing injury to that child?
Causing injury?
Like swelling,
Yes, sir.
redness,
Yes.
pain?
Yes.
All right. All right. Based on those statements, then the court is going to find at this time that the defendant has freely and voluntarily entered his plea of guilty, done so after consulting with an attorney, and has acknowledged his actions involved in the crime in this case. And on that basis, at this time, the court accepts the defendant's plea of guilty. Pursuant to the agreement in this case, the court and finds him guilty of battery in the second degree, a Class C felony. The court, pursuant to the agreement in this case, the court will sentence the defendant to 5 years of supervised probation, subject to the standard terms of conditions of probation, with a specific condition of the defendant's probation that he serve 120 days in the Baxter County detention facility. The defendant will also be ordered to pay court costs in the amount of $200, a fine of $1,000, the public defender use or assessment of $50, the public defender fee of $150, the statutory DNA fine of $250, and a booking administration fee of $20. All of those amounts that I've just read off will also be due and payable as a term and condition of the defendant's probation, payable at a minimum rate of $100 per month to the Baxter County Sheriff's Office, with the payments beginning within 60 days after his release from incarceration. This will be the order of the court, and the court will provide that the 120-day sentence will begin on the 19th of February and will be served the 120 days following thereafter. That'll be the order of the court. In placing the defendant on probation, the court has reviewed and is now signing the written terms and conditions of of probation of the defendant, making them an order of the court. The defendant's full compliance with all of those terms and conditions of probation is now ordered. The court notes that the defendant himself has signed an acknowledgement at the bottom of the written terms and conditions indicating that he has read, understands, and will comply with those terms and conditions of probation. He's directed to meet with the probation officer and get set up on probation. That will be the order of the court. Mr. Case, make your arrangements. You should report to the jail at 9 a.m. on Thursday, the 19th of February.
Jail right over here?
Yes. Yes.
Okay.
2015-27, State of Arkansas versus Elvin Weaver.
Your Honor, Mr. Weaver is here in the courtroom. At this time, I'd enter my appearance on behalf of Mr. Weaver. We'd waive reading of the information or plea of not guilty.
Plea of not guilty is noted on the charges. This case will be set on Judge Putman's docket for reappearance on February 19th to get on his scheduling.
Thank you, Judge.
All right, you may be excused. 2014-256, State of Arkansas versus Scott Jenkins. This case was down for a reappearance today to check on the status of the case, and it's next due in court on March 12th for pretrial with a tentative trial date of May 26th.
Thank you, Judge.
All right, you may be excused. 2014-174, State of Arkansas versus John Frank.
Your Honor, in agreement with the prosecutor's office, based on the fact it's not going to be tried on Tuesday, we're going to move to continue this case, which they've agreed to, so they can have further discussions with the prosecutor's office on this matter, if that meets with the court's approval.
We'll pull that next jury term, Your Honor, in case we're not able to resolve it, please.
Case will be continued till for jury trial March 12th, as opposed to, or I guess it's March 16th. Trial will reschedule to March 16th as an excluded period, and will if there's going to be a resolution of this case, I'll order a reappearance on March 12th.
Thank you, Your Honor.
All right.
May my client be excused?
May be excused.